yes, like Albert, I qualified as a barrister and spent some time in practice, private practice, and now, well, that qualifies me on the face of it, on paper, to talk about the law and changes to the law. But I also co-run a collection agency, and we specialise in international collections. And that, in reality, qualifies me to give this talk. Because I am not just a lawyer, I'm an end user. I use the legal system every day. And we use the legal system in an international context. And it's really as an end user that I'm going to talk to you today, as opposed to some dry analysis of international collection rules. I sat through a 4-year hell of law lectures, and I have no intention of inflicting any of that. So, from a practical perspective, I think we'll discuss some of the areas that we've found to be difficult, some of the challenges, and perhaps some of the potential solutions that we've identified. And really, those solutions, I'll go into a bit more detail in a moment, but those solutions require all of us as an industry to work together to bring about some of the changes which I think, in my modest opinion, we need to start thinking about making. So, testing my skills. This is the important disclaimer, right? Nothing which I say today is worth the paper it isn't written. All right, so just bear that in mind, please. You can sue me. There are a number of agencies for change. The worldwide litigation laws are, as you can imagine, they're complex. In a worldwide sense, they're diverse. The United Nations, the Hague Conference, the European Union, any number of establishments have all made Herculean efforts over a number of decades at trying to bring some sort of harmony to bear on the laws which govern and regulate the credit industry. And in fairness to them, they have made huge inroads. There's been a very great number of changes that have been made. I'm going to quote, or rather cite examples where, and it isn't going to be some sort of worldwide analysis of every jurisdiction. I know, I'm sorry about that. I know you're all going to be disappointed, so I'm just going to pick and choose small examples of where I think we can just usefully just look at the background. So there's 3 stages to this, what I'm going to say. 1, the background, the changes which are being made. 2, the effectiveness of those changes. And 3, the alternatives to litigation, such as they are. Are there any lawyers in here today? Anyone a lawyer? No? Yeah? No lawyer? Well, you'll still be able to feed your children at the end of this, so don't worry about that. The alternatives I'm suggesting are not necessarily going to put lawyers out of business, but they're practical solutions, really, to how we can avoid some of the pitfalls. Now, in Europe, as we know, it's been a number of changes have taken place in the last 3,000 years. I'm not going to go into all of them, but the Romans, the French, the Spanish, the Germans, the European Union, everyone's had a go at harmonising the European legal processes. But the reality is there are 811 million people living in 50 countries, speaking 23 official languages, that is languages recognised and used by the European Parliament, and 60 unofficial languages that aren't used. No, they're valid, just aren't used by Europe. There are 50 separate jurisdictions, and Europe and we, in some way, are expected to try and produce and work with harmonised laws within that framework. And it's quite frankly impossible. Don't get me wrong, Europe made very great strides at getting it right, but they're dealing, I mean, just in our own industry, there's a small little sample of the laws that we need to deal with: data protection, freedom of information, rights to privacy, consumer protection laws, telecom regulations, licenses, tracing, limitation periods. It's endless. And I could go on all day just listing the laws which need to be harmonised within, for example, Europe. So what happens? Well, we have various treaties, the Hague Convention. I know we're all familiar with the Hague Convention that governs how we litigate around the world. Almost every country in the world subscribe to the Hague Convention, and it's what most of us use when we seek to enforce judgments overseas. So the Vienna Convention, a huge amount of case law. I'm not going to go into it because I don't want to be bored with that. But these are just a few examples of the EU legislative changes which have been brought into effect over the last couple of years. And I'm just using these as examples just so that we can get a flavour of whether or not we think the system, the changes that are being made, are actually working to our advantage and the advantages of our clients. Because at the end of the day, we're the people who use the system. And it's our clients who stand to benefit or lose from using that system. So let's have a quick look. The European Enforcement Order. So this is something that was brought into effect so that we could all, within Europe, enforce judgments, not just in commercial cases, but of course against consumers. And on paper, it's great. On paper, we should all be able to do it really easily. In practice, it's hardly ever used. And why is it hardly ever used? Because you have to go to the nth degree to prove service, you've got to get all the documents translated. It is used in Holland, it's used in Belgium, and they're about the only two states at the moment that routinely use it. Everyone else just ignores it, and they carry on exactly as they did before, which is to basically seek judgments in the country where the debtor is resident. And that's pretty much the case all over the world, in consumer files. Late payment rules, again, on paper, a great piece of legislation. Throughout Europe, we can all charge interest, penalties, etc. in commercial cases. Well, that's all very well, but all that's actually happening in reality, and this was to protect the little guy. The little business was being protected from the big businesses who were penalising them by waiting for 90 days, 180 days longer before they get paid. All that's actually happened is the big businesses are using these late payment rules and these penalties against the smaller businesses because the smaller businesses don't have the financial muscle to fight back. So if the smaller businesses want the business, they get stuck with these late payment fees. No big business ever gets landed with these fees because they never do business again with a small business trying to enforce them. So it hasn't really worked. It didn't achieve the purpose that it was set out to achieve. Have I been misled? So, European Order for Payments and Insolvency Proceedings, I could go on, but I won't. The bottom line is this. Every year, I and most of the other larger agencies in Europe go to a big conference called FENCA, the Federation of European National Collection Agencies. And every year, FENCA say to us, the agencies, they say, we're in discussion with Europe, and we're making changes to the law. And Europe wants to effect changes which work to your advantage and the advantage of the clients. And every year, pretty much, FENCA say, but nobody ever tells us anything. We give you the opportunity to come and talk to us. And nobody ever says what the problems are that you encounter on a daily basis by making these laws, or trying to make these laws, work by incorporating them into your own internal processes. And they're right, because we don't. And because we don't really have the right to complain when the laws don't work in our favour. Because if we did actually go to FENCA, FENCA made the representations to the European Parliament, it may be that we'd end up with a set of harmonised collection laws within Europe, which actually had the effect of working to the benefit of our clients rather than just frustrating the process. Now, that's just one very small example of why the attempt at harmonising the collection laws, noble and worthy though it is, doesn't really, at a grassroots level on the ground, benefit hugely our clientele. So we need to consider, and I'll go through other examples because we litigate all over the world, and I'm just using Europe as a very small example, but we'll go through, Spain obviously will crop up. Sorry about that, Kevin, it's unavoidable. Along with Portugal, and but let's China, will also India. Each territory has its own separate set of issues and problems, which within their own legal jurisdictions, which means that I would suggest that we need to start looking at alternatives. And an alternative to litigation is arbitration. When I put this slide together, in fact, if you have the original, double click on it, it'll have all of the arbitration associations in various regions. So if at the end you decide that you want to know more about arbitration as an alternative, if you send me an email, I'll be able to give you the information about all the various arbitration services within your own territory. I'm sure you already know who they are. But largely it's been driven by the United Nations. The United Nations Council for International Trade Law has created a unified set of arbitration rules, the latest of which came out in August 2010. And it's an extremely full document that covers just about every facet of arbitration and every process that you need to have. And pretty much, with one or two exceptions, we'll go through them in a minute, pretty much every part of the world has at the very least considered putting in a formal process, a formal framework of arbitration. And I'll go through them now. So in Africa, we heard from Sam earlier about some of the difficulties which they encountered in Africa in terms of their own legal system. And they have, without wishing to be too disparaging about some of the problems that they've had, but they suffer from corruption, delays, all sorts of things. Interestingly, the World Cup had a huge effect on Africa. The whole world was watching an African state implement its laws. And it was hugely important that South Africa got it right. So what they actually did was they introduced, I don't know whether you remember in the news, these mobile trains, mobile courts based on trains. And what they do is they take the offenders and they snatch them, put them on a train, try them whilst the train was being taken to prison, presumably if they would be released, if they were found acquitted before they got to prison. I never found that out. But they were tried and then put in prison. And it was the fastest, quickest piece of justice that's ever been dispensed in Africa, pretty much, certainly in recent times. And it worked. And what's happened now is that's given a lot of the other African states the impetus now to start thinking about how they can copy that model, not just in criminal trials, of course, but in civil litigation. Fast, efficient justice. And that's what they're aiming to achieve. But they're a long, long way away from being able to realise that ambition. And so we really should be considering the alternatives there. And the alternative, an obvious alternative, provided you can get the parties to agree to submit, is arbitration. Because it's theoretically, it should be incorruptible. If you go to an arbitration service, a proper, recognised arbitration service, you shouldn't have the same problems with corruption that you get in some of the courts in some of the African states.